Having explored both the conceptual underpinnings and the practical realities of adversarial and inquisitorial systems in the preceding chapters, we now turn our attention to the question: how might the virtues of these two legal traditions be successfully harmonized into a single cohesive framework? This chapter examines the core principles that would guide a balanced bench approach. We investigate the rationales for melding adversarial and inquisitorial features, consider the roles and responsibilities of judges and attorneys in such a system, and discuss procedural innovations that can help ensure fairness, efficiency, and transparency. Along the way, we will address the potential pitfalls and critiques that any hybrid model is likely to encounter. In articulating these principles, we begin to see not only why a balanced bench might be desirable, but also how it can be institutionally realized. By considering the best practices from both adversarial and inquisitorial models, while consciously guarding against their common failures, a balanced bench becomes more than a theoretical aspiration. It emerges as a plausible design for modern judiciaries looking to handle complex, resource-intensive, and high-stakes cases. Whether the goal is to deliver justice with fewer errors, to encourage greater public confidence, or to make the most of limited judicial resources, this chapter offers a roadmap for lawmakers, judges, and practitioners seeking to pioneer a third way forward. The rationale for a blended model. Adversarial and inquisitorial systems each have defining strengths that many reformers are loath to abandon outright. Advocates of the adversarial tradition emphasize the importance of party autonomy, the right to confront accusers, and the role of lawyers in zealously safeguarding individual freedoms. Inquisitorial supporters, meanwhile, champion the active involvement of a neutral judge who undertakes a thorough investigation, theoretically leaving fewer gaps for injustice to exploit. While these virtues are typically pitted against one another in dichotomous debates, a balanced bench envisions harnessing them in tandem, thereby amplifying the best features of each. For instance, in a balanced bench system, robust cross-examination and adversarial testing of evidence need not be sacrificed merely because a judge is empowered to question witnesses or direct an investigative inquiry. Likewise, judicial initiative in evidence gathering need not preclude parties from advocating strongly on behalf of their clients. By adopting procedural safeguards that allow for both judicial oversight and adversarial scrutiny, courts can increase the likelihood that all relevant facts are presented, scrutinized, and contextualized, without placing an undue burden on any one actor. From an ethical standpoint, blending these models may also promote a healthier legal culture. In adversarial systems, there is often a risk that attorneys focus on winning at the expense of a fair accounting of the facts. Conversely, in inquisitorial settings, judges may be tempted to rely heavily on the findings of their investigative dossiers, risking confirmation bias. A balanced bench can foster a spirit of shared responsibility among judges, prosecutors, and defense counsel. Ideally, each actor is held accountable by the oversight of the others, creating a system that is more transparent and less prone to the pitfalls of unilateral power. Reimagining judicial roles. One of the most critical considerations in designing a balanced bench concerns the role of judges, specifically how to empower them to investigate proactively without compromising impartiality. Traditionally, adversarial judges have served as neutral arbiters, ensuring that no party violates procedural norms or rules of evidence. In inquisitorial courts, judges typically assume an inquisitive function, directly questioning witnesses and directing law enforcement to collect evidence. A balanced bench would assign judges an intermediary role that includes certain inquisitorial powers alongside adversarial checks. For example, the judge could be authorized to pose questions to witnesses at trial, particularly when lines of inquiry appear incomplete or when neither party has adequately addressed a significant issue. However, to preserve fairness, judges would be subject to rules requiring that such interventions be disclosed to all parties in open court, with opportunities for both prosecution and defense, or plaintiff and defendant in civil matters, to respond or object if they believe the judge is overstepping. Likewise, during pretrial investigations or case management conferences, a balanced bench judge might guide the scope of discovery more assertively, ensuring that critical evidence is not ignored because of resource imbalances or strategic silences. Yet, judges would not become full-fledged investigators in the manner of traditional inquisitorial magistrates. Instead, they would function as directors of discovery, ensuring that the parties conduct thorough and equitable inquiries. This approach aims to reduce the extreme passivity of a purely adversarial judge without granting unbridled investigative discretion that could compromise neutrality. In addition, a balance bench could rotate judges between investigative and trial phases, similar to some hybrid systems in Europe and Latin America, with sufficient procedural firewalls to prevent biases formed during investigation from influencing final adjudication. Alternatively, the same judge might oversee both phases, but with strict disclosure requirements and avenues for review if either party suspects partiality. These structural safeguards are critical in preventing the kind of unchecked judicial power that critics fear in inquisitorial systems. Ensuring procedural fairness. Procedural fairness stands as the bedrock of any legitimate judicial system, and a balance bench is no exception. In purely adversarial systems, procedural fairness is often equated with giving both sides an equal chance to present their arguments and evidence. In inquisitorial contexts, fairness is aligned with a neutral judge's responsibility to investigate all aspects of a case thoroughly. A hybrid framework must address these dual imperatives simultaneously. One possible route is to institutionalize a two-tiered approach to fairness. First, during the investigative or pretrial phase, fairness means that both parties have access to the evolving evidence record and can propose lines of inquiry. Second, during the trial phase, fairness requires that each party be allowed to question witnesses, challenge the evidence, and present independent expert testimony. The judge, meanwhile, would be permitted to intervene with questions, but only under transparent conditions that do not tip the scales. Procedural rules might also prescribe specific checks on judicial conduct. If a judge aggressively pursues a line of questioning that appears to undermine one side's position, the opposing counsel could request a sidebar or hearing to ensure the judge's interventions remain balanced. Moreover, standardized guidelines on how and when judges can introduce new witnesses or evidence could help avoid any perception that the court is abandoning neutrality. While such guidelines inevitably vary by jurisdiction, their overarching purpose would be to maintain a level playing field, supporting the objective of truth-seeking without compromising the rights of the accused or litigants. Balancing party autonomy with judicial initiative. One of the challenges in merging adversarial and inquisitorial features is finding the right balance between party autonomy and judicial initiative. In adversarial systems, parties have broad autonomy to frame the issues, select evidence, and question witnesses. This autonomy supports the principle that individuals should control their own legal fate. In inquisitorial systems, the judge drives much of the evidence-gathering process, which can reduce disparities between parties but may dilute their sense of control. A balanced bench might empower the judge to set certain investigative milestones. For instance, the court could specify critical witnesses to be interviewed or crucial forensic tests to be performed, based on an initial review of the case. Once these milestones are outlined, the parties would still retain autonomy to conduct additional discovery or prepare their own expert analyses. In this way, the judge's initiative ensures that all the essential evidence is gathered, while the party's autonomy ensures each side can still pursue unique avenues of investigation. This approach requires clarity about the judge's authority to introduce new lines of inquiry that neither party has pursued. When such authority is invoked, rules should require timely disclosure to both sides, including the rationale behind the judge's intervention and the steps to be taken next. By maintaining transparent communication, the balanced bench model can minimize surprises and safeguard the principle that litigants should not be blindsided by late-breaking evidence they have had no opportunity to challenge or contextualize. Handling evidence in a balanced bench. Evidence management is often a microcosm of broader legal philosophies, reflecting the extent to which truth-seeking is a collective, court-driven enterprise or a competitive, party-driven contest. In a balanced bench, Evidence rules would be designed to combine the thoroughness of inquisitorial discovery with the scrutiny of adversarial cross-examination. One hallmark of inquisitorial systems is the compilation of a comprehensive dossier. A balanced bench might require the creation of such a dossier during the pretrial stage, assembled under judicial oversight with input from all parties. This dossier would include witness statements, expert reports, physical and documentary evidence, and any relevant forensic analyses. Importantly, it would be accessible to the defense and prosecution alike, ensuring that no secret evidence is withheld from either side. During trial, adversarial testing of the dossier could occur through live witness testimony and cross-examination, allowing attorneys to probe the reliability of the evidence. Judges would retain the right to question witnesses directly, but counsel would have opportunities to re-examine or challenge the judge's line of inquiry. This combination ensures a thorough fact-finding process. The dossier prevents crucial evidence from being overlooked, while cross-examination guards against unchallenged assumptions. Another consideration involves expert evidence. In adversarial systems, each party often introduces its own expert, which can lead to a battle of experts scenario. In inquisitorial traditions, the court itself might appoint a neutral expert to provide an objective analysis. A balanced bench could embrace both methods. Parties would have the right to engage experts who can advocate their perspective, but the court could also appoint its own neutral expert to give an independent assessment. This arrangement provides multiple layers of evaluation, increasing the chance of uncovering any flawed methodology or bias. Accountability and oversight. Any effort to invest judges with additional investigative powers necessarily raises questions of accountability. In a balanced bench, judicial accountability could be preserved through multiple institutional checks. First, a system of appeals would remain essential, allowing higher courts to review whether judges overstepped their authority during the investigative or trial phases. Appellate courts could evaluate whether the judge's inquiries or decisions about evidence compromised fairness or indicated undue bias. Second, professional oversight bodies or judicial councils might be expanded to assess complaints about alleged misconduct or partiality. This would be especially crucial if judges are empowered to coordinate investigations in the early stages of a case. Clear regulations and regular audits of judicial decisions, coupled with transparent reporting, can deter arbitrariness and promote consistency. Third, party autonomy serves as an inherent check. Defense attorneys and prosecutors have the right to object if they believe a judge's conduct is compromising the neutrality of the proceedings. These objections, when raised in open court, ensure that the issue is documented and can later be scrutinized by an appeals tribunal. Moreover, a balanced bench might provide for team-based judging, wherein a panel of judges, rather than a single magistrate, shares responsibility for both investigative oversight and final adjudication. This collegial structure can dilute the power of any one individual, reducing the risk of singular bias or error. Potential criticisms and rebuttals. Any hybrid model inevitably invites criticism from traditionalists on both sides of the spectrum. Some adversarial purists may argue that allowing judges to take on investigative responsibilities jeopardizes the principle of party autonomy and could open the door to judicial bias. Yet this critique often fails to acknowledge that many adversarial jurisdictions already have investigative elements, such as grand juries, court-appointed experts, or certain judicial inquiries, and that these have not led to the collapse of judicial neutrality. From the inquisitorial side, reform skeptics may worry that by layering adversarial cross-examination atop a judge-led inquiry, the balanced bench risks creating procedural complexity and confusion. Will lawyers and judges step on each other's toes? Might the additional checks slow down the entire process, diminishing the inquisitorial goal of efficient, state-led investigation? These concerns, while valid, can be allayed through clear procedural rules, well-defined roles, and robust training for judges and attorneys. Indeed, many jurisdictions that have experimented with hybrid features, such as Italy or some Latin American countries, have managed to streamline these processes over time. A separate concern is that a balanced bench might be more expensive, requiring additional judicial training, expanded legal aid for indigent parties, and more oversight bodies. This is not an insignificant challenge. However, proponents contend that the long-term benefits of reducing miscarriages of justice, lowering appeals based on procedural errors, and bolstering public trust in the judiciary outweigh the initial financial outlay. Additionally, some economies of scale could emerge if more efficient pre-trial investigations reduce the frequency of lengthy trials. Implementing a balanced bench. Practical steps. Turning the balanced bench from theory into practice involves multiple stages of legal and cultural transformation. First, legislators would likely need to enact statutory changes to delineate new judicial powers and procedures, perhaps revising codes of criminal or civil procedure to codify the balance between party autonomy and judicial initiative. Second, judicial education programs would be essential. Judges transitioning from adversarial systems, for instance, might need specific training in proactive questioning techniques and dossier management. Conversely, inquisitorial judges might require instruction on ensuring adversarial challenges are fully heard in open court. Pilot programs could serve as a crucial intermediary step. One possibility is to establish specialized courts, for example, a balanced bench division, to handle specific case types, such as complex financial crimes or child custody disputes. Observing how these pilots function, evaluating issues of efficiency, fairness, and appeal rates would offer valuable data to lawmakers and judicial councils. If successful, these practices could be gradually expanded to the broader court system. Cultural change, too, should not be underestimated. Lawyers and judges alike may need to adjust to new norms. Attorneys who thrive in a purely adversarial environment might resist ceding some control to a proactive judge, while inquisitorial judges may worry about the introduction of more adversarial confrontation in the courtroom. Clear rules, consistent education, and strong institutional leadership can help align these stakeholders around a shared vision of justice that values both thorough investigation and rigorous adversarial testing. The balanced bench is more than a theoretical construct. It is an evolving paradigm that seeks to merge the strengths of adversarial and inquisitorial traditions into a cohesive and principled whole. In doing so, it offers a proactive yet disciplined role for judges, preserves critical adversarial protections, and strives for procedural fairness that accounts for both individual rights and collective interests in uncovering the truth. While not without its challenges, cost, complexity, and the potential for role confusion chief among them, a carefully designed balance bench can mitigate the worst excesses of pure adversarial or pure inquisitorial systems. Looking ahead, subsequent chapters will explore even more specific mechanisms for integrating cross-examination, judicial oversight, and evidentiary management. We will also examine how real-world examples of hybridization shed light on both the promise and perils of this approach. Ultimately, the balanced bench aims to reimagine justice for a world that has grown too complex, too interconnected, and too aware of systemic inequities to rely on the unexamined comfort of tradition. By taking the strengths of two venerable systems and molding them into a new framework, we can envision a future where courts are both rigorous in their pursuit of truth and steadfast in protecting individual rights, truly embodying a balanced administration of justice.